Welcome, everyone. This is Immigration 301, your advanced guide to understanding and navigating U.S. immigration. Together with leading industry experts and attorneys, we are exploring policy shifts, best practices, and innovative solutions that move the field forward. I'm Danielle Goldman, CEO, immigration advocate, and entrepreneur, and I'm bringing you critical insights and knowledge you need to move forward with clarity and confidence. This week, I'm thrilled to be joined by Jonathan Grode, who is managing partner at Green Spiegel. He's a law professor at Temple University and a fellow at the Talent Mobility Fund. If you're navigating your own immigration path, if you're hiring global talent, or if you are interested in learning more about the immigration space, you're in the right place. Let's dive in. My name is Danielle Goldman. If we haven't connected before, I am CEO of the Build Fellowship, and I've run a nonprofit called Open Avenues Foundation. For the last 8 years, we've been building CAP-exempt H-1B pathways for global talent, and I am thinking about innovative solutions for foreign nationals day in and day out. And part of what I have to do and what Jonathan has to do is stay on top of everything immigration policy related and understand what's going on in the ecosystem. And we're lucky to get some insight from Jonathan, who is partner at Green Spiegel. And Jonathan, if you want to introduce yourself, give a little more context, then we'll dive in.
Sure. My name's Jonathan Grode. I'm managing partner of Green Spiegel. I've been doing immigration for a long time, Danielle. We've known each other for a long time. In addition to running the practice over here, I teach at Temple University at the law school. I teach on immigration, law practice management, and I'm also a fellow of the Talent Mobility Fund, which really works to promote different ways of looking at high-skilled labor to the United States, including, STEM and early STEM career development. So the ability to meld all of those hats into one presentation is certainly something that I don't take for granted, and I appreciate being here with you today.
Amazing. Jonathan and I are in a working group together where we get a lot of insight from some of the top firms across the country. We talk with folks who are in academia and who are ex-State Department individuals. And we met because all of us are trying to keep our pulse on what's going on. And I thought, I asked Jonathan if he'd come to really share some of those insights with all of you today. We have a mix of folks who are from corporate and who are coming as HR professionals, looking out for what's coming up next for their own employees. And then we have foreign nationals who are also joining, trying to figure out what is going to be best for their path forward. So we're talking to a bunch of different kinds of people here today, Jonathan, but we'll really cover, to start, what's going on in the policy landscape, because I certainly am getting a ton of news from all different angles as to what is happening from a political change perspective when it comes to employment-based immigration. And I'd love to just understand, when you're talking to your colleagues at Green Spiegel, what's the sentiment going on in general? Does it feel like it's an overwhelming amount of change coming from the administration? It certainly feels that way from the news, but we don't trust the news fully anymore. There's a lot going on. So if you could give us some insight in general, that would be a good place to start.
I think one of the most fascinating things about what's going on right now, Danielle, is that we really don't have any new immigration laws. Like, there's actually no new law. It's not like Congress has passed anything. Yes, the big, beautiful bill really ramps up the allocation of funds as it relates to enforcement actions. But in terms of actual law, there has not been much of a change. So we've had a lot of policy. We've had a lot of executive orders. We've had a lot of attempts at changing things, rewriting of the policy manuals and things like that. The best analogy I can give you is, do you like baseball? Okay. So,
I'm a Red Sox fan.
well, that's okay. I'm a Phillies fan, but we got an American National League thing going on.
There it is.
Imagine that I'm a pitcher, and in order to win a case, I have to throw a strike, and the government's the umpire. Every umpire has a different strike zone, and
Yeah.
this particular government has one of the narrowest strike zones you will ever see. So if I'm throwing a meatball down the middle of the plate, like an H-1B for a university, for a professor that's teaching engineering, and they have a PhD in engineering, that thing's cruising right down the middle. It's a meatball. That's like, it's always going to be a strike,
Mm,
irrespective of who the administration is,
mm,
as long as the laws are the same. It's the stuff on the margins that's having the problems.
mm,
It's the things around the edges that we used to get the benefit of the doubt. We used to get that call that we're not getting the calls anymore. And you're seeing that in adjudication. You're seeing that in the way things like NIWs are being adjudicated. You're seeing that in the way that they're looking at O1s and some of these more subjectively driven cases, where the previous administration had a propensity to approve, this administration has a propensity to deny.
mhm,
But more than that, they're allowing policy to carve out even more and more of a narrower niche. And
mhm,
then on top of that, we're starting to see for the first time them engaging in the rule-making process itself, where they're trying to amend the regulations. And all of this is being done in the name of restrictionism. So if you really look at it, everything is getting tighter and tighter and tighter. Less and less people are being qualified, and that is changing demand.
mm,
So if you look at like what's going on with the students, for example, and the heavy push on an ideological battle to sort of quell the world of the woke monster, and the fact that social media handles, started to become a methodology for denying visas, or the fact that the State Department just canceled another 6,000 F1s. Not only is it precluding individuals from coming to the United States based on a policy interpretation of what is national security,
mhm.
but it's also quelling the desire and want of people to come here in the first place.
Right.
Why bother? Why bother if you are going to be faced with worry about your status at every single turn? And I
Yeah.
think these are the things that we are seeing. Now, I blame both political parties for the ineptitude of Congress to pass any sort of meaningful change in, like, realistically 40 years now. 40 years since there's been any sort of like meaningful change to the immigration system. And the closest we got most recently was in 2013,
Yeah.
where we had like an immigration overhaul bill led by a gang of 8 senators, and the most prominent of them, almost ironically at this juncture, was Marco Rubio.
Right.
And when that failed, and Obama decided to pass all those executive orders regarding L visas and DACA and all these other things, which most immigration advocates would agree with, but by relegating that to the executive branch, Congress has abdicated itself of responsibility as it relates to immigration policy.
Mhm,
And we now find ourselves in a posture where we are ostensibly dealing with a new set of rules, a
mhm.
new umpire, if you will, every 4 to 8 years.
Right.
And understanding how that umpire is going to call the game dictates not only corporate behavior, but now it's gotten so acute, it's affected foreign nationals want to come to the United States. And I
School.
think
Right.
that in there is our biggest challenge.
Mhm.
So I know that was like super long-winded,
Yeah.
but
No, I
like
actually,
ultimately, yeah, but like ultimately, it's not so much the basis for what they are doing that's static. It's the how they're going about doing it.
mhm.
And
It
yeah,
makes a
it's
lot of
cool.
sense, Jonathan. I want to go with this theme of baseball because
Okay, I'm with you.
there's when we're talking about this strike zone
Yeah.
and the parameters that are, kind of getting blurred, or who really has the power to determine that strike zone? Is it USCIS? Is it the administration who's the umpire when the courts are involved? And I ask because when everyone is monitoring the news and everyone is very reactive, companies are reactive, students are reactive, I'm reactive, right? We're all either like emotionally or actually making business decisions that are reacting to the news about these decisions that are being made and rules being published. But should we be reacting to everything, or is like really, can you just talk about the power dynamics here and how what we should be following?
Yeah, so that's a great question. Using the baseball analogy, I would say, unlike Major League Baseball, there is video review of balls and strikes when it comes to the law. So we do have the courts involved. And the courts are actually what's framing the actual policy. And then I think there's a little more subtle thing going on that I'll mention. But just in terms of the courts, I think that this is a government of sledgehammers and not scalpels. I think that these guys do what they think is right, and they will take as big of a swing as possible because they feel a mandate from the American people, and that's why it's so much heavier than Trump 1.0.
Yeah.
And then they will allow the courts to come in and narrow it and refine it. And it's a very interesting push pull. And I obviously, given the audience and not knowing, like, if it's mainly lawyers or not, I don't want to go into the dynamics of the changes that the Supreme Court has made
Right.
and who can file for injunctive relief and how that happens. But know that immigration advocates and immigration groups are challenging the administration. And I think that they almost don't care.
Mm,
I think they're like, let's take the headline, let's take the big swing and let the courts narrow down
yeah.
what the actual rule and policy can be. So,
Right.
if we talk about Harvard and saying, Harvard, you can't issue student visas anymore.
Right.
You violated CVIS. You are not properly administering the F1 system. And Harvard's like, that's not right. We are doing it. We're filing for injunctive relief. The courts grant that injunctive relief.
Yeah.
So Harvard can still issue student visas and they're being adjudicated. But I don't think the administration is fussed. I
Hmm.
think they're like, you know what? We got it across all news channels that we're not letting Harvard get away
Yeah.
with this, whatever this is.
Interesting. So some of the
So
moves are optics for the
it's
administration.
all optics. It's about controlling the masses by dramatically effectuating the few.
Right.
They're trying to change perception and they're trying to change behavior.
Hmm.
And I'll tell you, they're doing a really good job at it.
Yeah.
Like, so if you take, for example, Danielle, what happened with the border crossing back in the spring, we saw all these news reports of Canadians coming across the border and being detained.
Right.
German green card holders getting detained, people being put in detention for days. Have you heard much about that this summer?
No,
No, not at all.
not at
Do I
all.
get calls every single day with people saying, I'm scared to travel?
Yep.
Every single day, we're getting calls about people scared to travel. They call me counselor at law, but I really start to believe it's because I am just doing counseling. Like that's what a lot of my consultations are.
Yes. I'm hearing that from a lot of immigration attorneys that this is what it's becoming. You have to be a
So,
social worker,
yes, well, I prefer therapists, but
therapist.
however you want to do it. But the perception has been affected. Tourism in Las Vegas is down 20% this summer, mainly from Canadians not wanting to come. There's a boycott, a Canadian boycott on US alcohol. It's affecting the way people like consume
Mhm.
beverages.
Mhm.
It's the perception of what's happening.
Yeah. And
Now, sorry,
yeah,
go ahead.
go ahead. I want to dive into some real examples of things that we're hearing right now and get your take on what you think is perception versus real.
Okay,
Because this is a game of perception versus reality.
I'm ready. I'm ready. I'm ready.
I think that the first one you brought up was Harvard, right? That was a case study in what we are about to see in a slew of upcoming potential efforts from the administration. And so we can take that, the realities for what ultimately, the courts decided with Harvard and apply it here. But the next thing that we're hearing is about the uncertainty of OPT. We are hearing and seeing, and I'm reading Stuart Anderson articles that the new head of USCIS is going to be very much inclined to get rid of OPT. Now, Can you just explain to us how do you get rid of OPT? Is it possible? Is this optics? What does this even look like? And does the administration control it?
I think you have to look at the two types of OPT first.
Yep.
So you have like your general grant of OPT, and then you have like the STEM extension of OPT. The STEM extension of OPT is not all that old in the grand scheme of things. I mean, it came about in the mid 2000s primarily to address the fact that the quota was being hit and was sort of a band-aid. There was a number of court challenges, and it withheld those court challenges. And it was actually expanded from a 17-month extension to a 24-month extension. I think those court challenges were essentially going after the rulemaking procedure that led to their creation. So I do think like it is very much possible through a regulatory mechanism that STEM OPT could go away.
Yep.
Like I do think that that one is on less solid ground than regular OPT.
Hmm.
If you actually look at the statute that created it, it is actually, there is some room for interpretation. And with Loper Bright having replaced Chevron deference to the ability of administrative agencies to carve out rules and regulations and having the immunity to do so, I think that they could actually challenge it anew under that mechanism as well. Because I felt like Chevron deference, and for those of you that don't know, Chevron is like one of those cases you learn about in law school, where it pretty much said if Congress gives the authority to a regulatory agency to make the rules, then those rules are presumed to be correct because the agencies have more knowledge on a particular subject matter. That was overturned in 24 while Biden was president and replaced with Loper Bright, when Loper Bright pretty much said, no, congressional intent can be really looked at to determine whether or not a regulation could stand on its face. So I think that both could be challenged. My gut says if they really, really, really push it, there's a very good chance that a regulation could get passed that would eliminate STEM OPT.
Hmm.
I think that if STEM OPT is eliminated, um, you will see some injunctive challenges under the Administrative Procedures Act.
Yep.
And we do know that these proposed regulations are coming down the pike, Danielle.
Yep.
And one of the best things that you could do if you want to be an immigration advocate is do notice and comment. So anytime a new regulation appears in the Federal Register, you have an opportunity to provide notice and comment. The final rule is meant to address all of the questions. So if you lob in a lot of questions, it's going to take them longer to get to final rule, but it also creates fertile ground for challenging the legitimacy of the regulation itself under procedure rather than substance. So there is some opportunities for advocacy in there.
That's amazing for folks to know. And we can follow up with some opportunities to advocate probably on this call after this call, Jonathan. There's from the group that we're in, there's some action happening on some of these items regarding okay, so you think that this is a reality that STEM OPT might go away.
I think it's reality, yes.
Okay, there's a lot of folks on this call who are representing companies here, or who are attorneys advising companies. What are you telling your clients? Are you having them prepare now? Should companies be thinking about risk mitigation? And if so, what are the paths they should be thinking about right now?
I mean, this whole situation with this administration is actually having us rethink the entire transition period from H-1B to, sorry, from OPT, from student to worker.
Hmm.
Um, I think that it is fundamental to start having these discussions on how you're going to address bringing in new people to your ecosystem that are students. And
Right.
there's a variety of things that we're advocating for, and I know we're going to unpack that a little bit further, but just on the outset, like assuming that things are going to be status quo and that we're going to have these tools available, I think a lot of people are going to be caught flat-footed.
Mm.
So thinking of alternatives to STEM OPT, whether it be leveraging the J1 researcher category for individuals that have STEM, which I know we're going to talk about, something like your organization, where you have the opportunity to partner with universities in order to establish H-1B classification for those that are like hyper intelligent on the PhD level, maybe going into O1, or
Yep.
even something as simple as a fundamental international company having an individual continue their practical training abroad
Right.
for a year in order to activate an L intercompany transferee visa
Yeah.
later. These are all sorts of strategies that we're talking about with employers now.
So
That's
we're
what,
talking,
yeah.
I mean, it is important to start having the conversations, but it's hard to predict the timing here. So are you like with a change when it comes to OPT, could that happen in the next few months? Would it take a year? Is it going to outlive up to the Trump administration because it takes so long to get through rulemaking processes or changes to uh, this kind of rule?
I think that that's a tremendous question because it's very, very, very hard to predict. But let me get out my crystal ball.
Yeah,
Here we go.
that's all we can ask for.
So I would anticipate we're going to see some of these proposed rules come within the next month. Then usually there's like a 60 or 90-day comment period. Then it takes them a little while to, yeah, I guess they could even do 30 days, but it's usually a 60-day notice and comment period. And then it takes them a while to put it out. And then there's the final rule, which let's just say sometime in the spring. Now, I know that one of the rules that they're looking at changing is the way the H-1B cap is counted.
Right, that was the next question of perception or reality.
Yeah, and I think that that's very much a reality, but let's talk to them, talk about them together because I actually think from a procedural perspective, you're going to see them sort of hit at the same time, with the
Okay.
idea being that they become final rules prior to the start of the next H-1B lottery,
Uh-huh.
which is going to roll in March of 2026. So my best guess is that it is the administration's prerogative to try to have these new things in place within the next 6 months.
Mm.
Now, I don't think they're going to get their way because I think there is going to be somebody probably a lot smarter than me and you or whoever else is on this call who figures out a way to get like an injunction pushed across the table.
Yeah.
Um, there are very, very, very smart federal litigators in the immigration sphere. We do some impact litigation in our firm. I don't get involved with that side of
Yeah.
it, but I do think that there will be some sort of injunctive relief. How that plays out in the court system and what ends up happening there could be anybody's guess. Chances of it being able to span through to the end of the Trump administration are pretty unlikely.
Hmm.
But I think that the midterm elections in and of themselves could factor into how heavy the government pushes. Because if we see like a tremendous, essentially rebuttal of the GOP agenda through a midterm turnover, some of these policy changes could be mooted out by actual laws being passed and pushed through, what then get vetoed by the president because you probably don't have a supermajority. But the political aspect of it could take reign.
Hmm.
But I think it would be like a heavy mistake to think that the government is not pushing for both some sort of modification to OPT and simultaneously a weighted average mechanism for H-1B cap selection.
Hmm. And can you just take 1 minute to explain that weighted average mechanism from your understanding for anyone on the call who doesn't know that the other proposed, it's not just getting rid of STEM OPT is something that has been proposed and as Jonathan has said is a reality of change that can happen. The other is this weighted H-1B reform. I was called out by a colleague the other day for calling it a merit-based H-1B lottery system because that was the Trump admin one's language that was used to determine and they very much convoluted wage with merit. And we know that foreign nationals are sometimes the most brilliant, but are paid a level one wage because they're startup founders, they're working for a nonprofit, or they are out of school and getting an entry level job and are highly valued and have potential, but the company is paying level one, level two wages. So if you can explain like what your take is on what the rule says today and what that means.
I mean, we don't, so the current rule is like anybody who puts in a lottery ticket gets a lottery ticket. And they have 20,000 of them set aside for people that graduate from a U.S. institution with a master's degree or higher. It's called the master's cap. Currently, Danielle, if you have a master's degree, it's like you run against the master's cap first, and if you don't get picked there, you actually get a second lottery ticket annually against the regular cap. Every year it's oversubscribed. There's usually, when you get the real numbers out of it, it's about 400,000 filings for 85,000 spots. Inherently, people are left in the cold. The Trump administration, I think their rationale here is by favoring those that have higher wage levels, you're providing more opportunity to U.S. workers for entry-level positions into professions. I think that that's the logic behind it.
Mm-hmm.
But there's a lot of things that are unclear because we haven't actually seen it actually published yet in the Federal Register. If we have a part two to this, we might be able to unpack it further. But essentially, they're looking at people who, when you look at a prevailing wage in the online wage library, which is comprised by the Bureau of Labor Statistics, there's 4 wage levels for each occupation classification. If you're in a higher wage level, you're going to have a weighted benefit of getting selected in the H-1B cap lottery.
Mm-hmm.
The problem I have with this, and this is where I want to see what's going to come down the pike, is a lot of categories are very similar.
Right.
So, let's just say, for example, you got a startup founder
Mm-hmm.
and they're calling them CEO. But are they really a chief executive? That chief executive wage scale is really, really, really high. They might be level 1 CEO. But are they really functioning as a CEO, or are they more of a general operations manager, which is another category with much lower wages, where you could pop them at wage level 4 there and increase your chances? So the way the jobs that are categorized is going to sufficiently influence the system that I don't necessarily think the desired outcome of the administration is going to be what they're intending it to be.
Mm-hmm.
Just compare the wages for a marketing manager versus a market research analyst.
Right.
2 different occupation classifications. Arguably, people operating in this sphere might qualify for both.
Yes.
So you're going to put that person in at wage level 4 market research analyst before you pop them in at level 1 marketing manager.
Sure.
So I think the wage level designations are going to be interesting. Now, is it going to be just wage based? Now, that would be fascinating if they're saying, okay, you make above $80,000 a year, you have a weighted lottery ticket. If it's below
Mm-hmm.
$60,000, I'm not quite sure how they're going to actually play it out, but we do expect the proposed rule to come out soon, and it will be interesting to see where people play down on this.
Right.
But I think ultimately what that is doing is it's going to chill the use of the H-1B lottery. It's
Mm-hmm.
going to make it harder. It's already a very expensive proposition for an employer just based on fees alone. I mean, it is expensive. The government fees are more than my fees.
Right.
And I'm the lawyer, right? I'm supposed to be the one charging the most. So it,
That's
it
right.
is it is very fascinating. So I would say that that is in the reality bucket as well.
Yeah. So interesting. I had definitely only considered your first iteration of the way this is going to go, which is that that it is by prevailing wage within each specialty occupation. And in my thought process is, okay, are companies just going to move employees to remote areas, are where the wage caps are lower. What are the solutions that companies are going to embark on? You gave one, which is just choosing the occupation that the individual is qualified for, but they are they could qualify as a manager, but they're going to use the SOC code for just the analyst. So there's definitely going to be strategies, but I hear you on as a whole, industries will make business decisions based on looking at the new rules and the realities for their workforce. So we have a couple questions actually on the first question's on
No.
the effective nature of whether or not making these public comments and taking the time is worth it. People are trying to calculate, and I'm in that bucket of what is the actual result of taking the time to do a public comment, and does it actually mitigate the final rule?
I think that this particular time it is like inherently important for more people to comment.
Hmm.
Like they can bucket and group comments and address them in the final rule together, but the more people that are commenting, the more likely that they amend the rule, the more likely that it slows down the process, the more likely that you're creating avenues for uh, the ability to challenge it or seek injunctive relief.
Hmm.
So I would encourage everybody to make a comment. Even if your comment is like, I don't really like this because I think it's unfair. I mean, just pop it in there, make a comment.
Yeah.
So I do think that the more that you can certainly make comments weighted in the law. I know there's a big movement from economists to make comments. I think that these are all things that can actually effectuate the process, and I would encourage you to do so 100%. Rarely do I say that. Sometimes I have more of a fatalist approach to it, but this is going to be like such a fundamental shift.
Hmm.
And I think there's going to be so much attention around it and so much advocacy around it that the more you can give the people that are going to be litigating this, like angles and avenues that they might not be thinking of, the better.
Yeah.
So yeah, 100%.
And I know we don't have all the details right now, but there's a question that someone had about the weighted H-1B levels and whether they only would include base pay or whether it would include liquid stock options, which so many startups are going to have questions about.
Yeah, so it's not about base pay, it's about guaranteed compensation.
Hmm.
So if you assign a par value for stock before it's like traded or before you go to Series A, or if you're giving them at like a pre-money like amount for, let's say, angel investors or venture capitalists, if that's assigned and guaranteed, then yeah, maybe you could argue it as part of salary, but it's a tricky argument to make because it is not a guaranteed valuation.
Mm.
Um, Things that do count that aren't ordinarily considered are like if you give them a car, and that's like, a benefit that has a true value. Like sometimes you can include that aspect of it. Some employers provide housing allowances and things like that. That's compensation. Essentially, the way you got to look at it, if it's income or some sort of contribution which is subject to taxation and it is guaranteed, then it is included in the wage. So remember when Danielle, you went on Price is Right and you won the car and then they sent you a tax bill for the car?
Right.
That's
Right.
income.
Yep.
That's income. It's your
Right.
car. You got it. You got to pay taxes on it. So,
Yep.
yeah, that is the way that plays out.
Okay. Super interesting. So we'll get back to some other questions towards the end, but I want to keep moving because now that we're talking about some of the realities of what could potentially happen, whether it's related to OPT removal or the changes in H-1B, it's more important than ever that we think about creative strategies and that attorneys are thinking about creative strategies and what tools are working and what is actually within that strike zone that's going to continue to be a tool for everyone to leverage as we think about advising foreign nationals moving forward. So I want to dig into to start with J1s because you had mentioned that, for if our goal as a nation is to figure out tools to retain international students or bring folks from abroad into these entry level positions, can you talk about J1 programs and how you've seen them actually be a tool for the workforce? Because that's something that is not necessarily always known.
Yeah, I love the J1. Like, let's just start out by saying I think it is a spectacular visa. For those of you that are not familiar with it, it is an exchange visa. It was created around the same time as the Peace Corps, Danielle, and it was like really a mechanism to get people from abroad to come over, feel what it means to be America, fall in love with America, and then go back to their home country and spread the gospel of America. But
Mhm.
over the years, the Department of State has expanded the use of the J visa into multiple categories, all the way from au pairs to camp counselors to foreign medical graduates, training and residency programs to researchers and scientists.
Mhm.
And the researcher and scientist mechanism of the H-1B has traditionally been housed within universities. And it's sorry, of the J1 has been traditionally housed at universities. And within that mechanism, you've been able to hold the J1 for up to 5 years. Recently, and I'm talking about within the past couple years, for some really great work through the Talent Mobility Fund, through some other individuals, through creative thinkers within the J1 visa realm, that was expanded to allow private employers to utilize the J1 for early STEM development as long as that individual is engaging in some research. Some research. So it's not none of these solutions that we're going to talk about, and I think this has to be really clear. None of these are panaceas, Danielle.
Right.
None of them are cure-alls for all the ills that are going to befall every immigrant. But it's understanding the tools that are available so you can pick the right one for your situation.
That's right.
The J is something that must be considered at this particular juncture, must be
Mhm.
considered. Why is it so important? Because, like I said, under the Biden administration, it was expanded to allow private employers to seek J1 sponsors to be the host of a J1 if sponsored by an agency that has this research designation.
Mhm.
And now all of a sudden, if you're engaged in a STEM activity, you have an alternative to OPT. You have an alternative to H-1B. But people didn't really grab onto it as quickly as we would have thought. And do you know why?
No.
Because the J1, because it's found in an exchange, a lot of people that would get the J1 had something called a 2-year home residency
Yeah. Yeah.
requirement.
Waiver requirements, right?
Right, where you had to go back to your home country for 2 years before you could switch to H-1B or green card. And a lot of people were like, okay, well, why am I going to just kick the can down the
Right.
problem? Why am I going to kick the problem down the can? Why am I going to just keep pushing it, pushing
Right.
it, pushing it, and pushing it? And the reality is they're right. If you
Mhm.
were from India and China and you're getting a J1 and it's valid for 5 years, but you have this huge question mark hanging over your head, like, am I going to get a waiver? Am I going to get a no objection statement? Am I going to be able to stay? It didn't have enough of a permanency feel to it that made it something that was attractive to lots of people.
Mhm.
But the Biden administration did something spectacular. And in immigration spheres, Danielle, I think it is one of the most underrated moves that we've seen
Right.
in that they amended the skills list. And the skills list are a list of all the countries and what areas of training the individual is required to go back to their home country for. And they removed countries wholesale from this list. Just remove them. So India no longer has a 2-year home residency requirement. China no longer has a 2-year home residency requirement. And now all of these nationalities that were scared to even consider the J1 have this as an open opportunity. I was going to say avenue. I was going to say avenue. Have this as an
Too easy.
opportunity. Have this as an opportunity to mitigate what potentially could happen within the OPT realm,
Yep.
to have another alternative if the H-1B becomes so hard to use, especially for startup entities.
Yep.
And all of a sudden now we have a very, very, very viable mechanism for utilizing the J1 as an alternative.
Mhm.
And I don't think it's getting the attention it deserves,
Yeah.
frankly. I think it is. That change to the Federal Register came at a very tumultuous time within the politics of the country. We're talking about
Right.
December of 24. There was a lot of things cooking around there. There was a lot of concern. There was a lot of worry. There was a lot of distractions.
Yeah.
And coupling that with the daily distractions that we're getting now and the
Yeah.
changes, you can understand why adaptation has not been as widespread as we would have thought or liked.
Right. And with the J1, one of the things that I mean, it's such an incredible tool for companies to be able to leverage. What what do you tell? I mean, so many companies that come to us to talk about, they're weighing lots of options, right? And I'm talking to companies about cap exempt H-1Bs, which we'll get to in a minute. One of the key considerations for companies who are thinking about J1 or have folks in J1 is that they can't, there's not the dual intent nature of it. And so when you have someone from India or China and you're talking about keeping them in a J1, how long can that last? Like, what does that look like from a long-term planning perspective with someone from India or China? And when would companies, like, you are constantly thinking with your company partners about investments that they're making and the longevity and the whole end goal of this talent. So when you see the J1 as part of a story for someone and their long-term immigration plan, like, where does it fit in?
Yeah, I mean, I think you raise a point. I mean, look, like I said, it's not a cure-all.
Right,
So the J1 having like a non-immigrant intent quotient to it makes it challenging to utilize when you're thinking about somebody that wants to remain permanently in the United States. Frankly, you're not even supposed to have that intent.
right,
So it also creates some like awkward situations, like where you're saying to somebody, "Well, I can get you a J1," and they're like, "Well, I really want a green card." You
right.
kind of have to like,
Yeah.
let's not talk about that now. I I think of it as a bridge. I
Hmm.
think of it a lot the way I look at OPT, for example.
Yeah.
It's a transition to something else. Now, what I think is great about it is that it creates the opportunity to maybe skip the H-1B completely.
Yeah.
I think it gives you an opportunity to say, okay, J1, you're a startup. Let's look at the O1 criteria. O1, the visa for extraordinary ability, no annual cap limitations, available year round, which is based on accomplishment. And
Hmm.
whether or not you can leverage the J1 to not only build your brand or continue your research, but simultaneously use it as a way to augment your reputation so that you can potentially qualify for O1 classification.
Hmm.
Sure, that's one way that I look at it. I also say, you know what? Now you got 3, 4, 5 more time opportunities to try the H-1B lottery, and maybe you'll hit it. And
That's
for
right.
some nationalities and some circumstances, you might be able to look at it, leveraging it into a change in circumstance that would allow you to consider permanent residency well after visa acquisition. You got
Hmm.
to be careful how you present the mental state when it comes to intent associated with visas.
Yeah.
I think that this is that in particular is something that this administration might glob onto at
Hmm.
some point just because of the very subjective nature of intent and the way that it's associated with different visa classifications.
Yeah. That makes a lot of sense. I mean, this is all about bridging and getting creative with what gives you more chance at a lottery, or what gives you time, buys you time to get an O1 so that you can get into a status that allows you to file the green card. So that
And
makes,
exactly. And
yeah,
like I think it also brings us around to what you know better than anybody else, which is
right,
frankly like how to use cap exemption within the
right,
H-1B.
right,
Because when I'm consulting with foreign nationals directly, I say to them, don't just limit your job applications to for-profit employers.
right.
You should be looking at universities. You should be looking at nonprofit organizations affiliated with institutes of higher education. You should be looking at nonprofit research organizations.
Yeah,
Or you can be looking towards concurrent employment.
that's
And
right.
that's another thing that I don't think people appreciate as much as they should. So, just to kind of like lay the land here, if you want to work for a for-profit employer, you got to get picked in the lottery. You want to work for a nonprofit entity that is cap exempt, you don't have to get picked in the lottery. What people don't realize is that you can combine the two.
Hmm.
And if you're anchored, as I like to say, in a non-profit, non-cap subject entity, and that is a part-time responsibility, then you can concurrently hold an H-1B for a for-profit entity.
Hmm.
And you could theoretically go to your professor and be like, Oi, this research project we've been working on throughout my entire master's program, it could use a little bit more of me. Doesn't need full-time me, but do you have the budget to hire me for 5 to 10 hours a week? And the PI is like, sure, and goes and gets permission. You have an H-1B with that PI for that part-time work. You can fill the gap with a concurrent at the same time H-1B with a for-profit enterprise that would be cap subject.
Right.
So there is that sort of middle ground hybriding activity. Now, again, there's no cure-all here. You
Right.
lose that nonprofit gig, all of a
Yeah,
sudden that for-profit gig is no longer viable.
exactly.
So you got to be really, really, really careful.
Yeah.
But I think, if you look at your program with Open Avenues, if you look at some of the other companies that are engaging in, or nonprofit organizations that are engaging in setting these things up, it's another tool to be considered.
Hmm.
And I think this is a great opportunity for you to talk a little bit about
Yeah,
how Open Avenues is structured, because it is a novel approach. It's
totally.
not for everybody, but it's definitely for somebody.
Yeah, I think I appreciate the call out. And this actually started and still exists as an initial model where universities, as you mentioned, hire part-time foreign nationals, and those foreign nationals are able to go work full time. And the model that started in 2014, leveraging this cap exempt concurrent employment potential, is called the Global Entrepreneur in Residence Program. And GEIR, the Global Entrepreneur in Residence Program, exists for founders, and many states, even today, California has funding for it, Wisconsin just passed funding for it. This model where the universities can actually sponsor these part-time roles. But the challenge, which you know quite well, probably from trying to set this model up, is that the universities, especially right now, don't have a great interest in in getting involved in the immigration world if they don't have to. They're already under scrutiny. They're already, under attack in many different ways. And the reality is they're not going to open up, tens, if not more positions for foreign nationals to be able to get this kind of part-time cap exempt H-1B sponsorship. But that actually created the impetus for us to start Open Avenues Foundation, because we know that there are incredibly talented founders and high-level professionals and researchers and brilliant folks out there who work in industry and would be willing to contribute 5 hours a week of their time to train future workers and train students at colleges and universities. And the other kind of cap exempt organization is a nonprofit affiliated with colleges and universities. And that's why we started the fellowship program, the Build Fellowship, which creates those positions for our current foreign workforce to be able to train Americans at our US colleges and universities. So we do get cap exempt status for individuals who are working at companies, not just founders, but mid to senior level talent. And it allows them to continue to work. And we're seeing some industries need this tool more and more. And I think it's interesting to look at this on an industry basis of like, what does our future AI workforce look like? And what is the future, we need to invest in semiconductors as a nation. And I have a law firm that is focused on veterinarians, and
Hmm.
they cannot bring over enough veterinarians to fill this massive talent gap in the country. And that's really, a good case for why we need to use these kinds of tools, Jonathan, and why we need to leverage these creative solutions. And we're talking about cap exempt H-1Bs. I know there's lots of folks talking about J-1s. When it comes to cap exempt H-1Bs, you and I had talked in preparation for this meeting about what does that mean for if there's a wage-based lottery system. I mean, what?
Well, this is where I think it's fascinating, because the lottery and the wage-based stuff seems to only apply to the lottery.
Right,
And there's no quota on cap exemption. So I
right.
don't see how a wage-based system would effectuate nonprofits. Now, I know there's a question in here: if the bill gets passed, is it possible that cap exempt H-1Bs would also be subject to the lottery? Sure.
Mm-hmm.
That I think that would take more of an act of Congress to amend things rather than a regulatory change, just the way it's
Right,
written. Sure, you could see that, but as of right now, I don't see that happening in my
right,
sort of fact or fiction bubble, if we're bringing us back to the
right,
likely or unlikely.
right.
But I do think, as far as uh, I do think as far as the weighted cap, these alternative mechanisms for H-1B acquisition through partnerships with nonprofit entities could be a saving grace to a lot of people who are going to be priced out of
Yeah.
raising salaries up to level 4.
Right.
I mean, fundamentally, some companies won't be able to even do it
Yeah.
because of like pay scales and wage levels and that, you know what I
Mhm.
mean? So it's it's a very real possibility
Mhm.
that the changes to the wage level system could make these alternative mechanisms more attractive than they have been in the past. And it's
Yeah.
certainly something that more companies are going to have to consider.
Yeah. Really interesting. Is there anything that you want to talk through in terms of other creative solutions, whether it comes to green card strategies that you're seeing companies employ more of because of the volatility in the space, or, we talk about O1s, we've talked about O1s. I mean, I think a lot of folks on this call probably have a good idea of what an O1 is, but maybe you're seeing other creative strategies being employed by companies using the O1. So either one of those categories, if you want to dive into as our last one before we open up for
Well, I love the O1 just because we know what the standard is. Like they give you a
Q&A.
list of criteria, you have to meet three, and there's some subjectivity to it, but I love it. Like what I always say is you may not be extraordinary now, but you can make yourself extraordinary.
Yeah.
It has like that very American can-do side to it. Like if you
Yeah.
bust
Love
your
that.
hump and you put the effort in, you can qualify.
Yeah.
And I think, between OPT and J1 and H1B, like you can get to O1 with a bit of time.
Yes.
And I think there's always this surprising like corollary benefit to dipping in on the O1, which is if you build your own personal brand, you build your business's brand at the same time.
Mm.
So I really, really like that.
Yeah.
And frankly, I do a lot of consulting with people who when they write to me and they're like, "What do you think about no one?" I'm like, "You're not there yet, but let's
Yeah.
talk about how we can get you there."
Totally.
So I like the fact that it's almost like a choose your own adventure kind of visa classification.
Mhm.
I like the fact that it rewards hard work and ingenuity. Um, and some of the criteria are like low hanging fruit, like judging work of the others. If of others, if you have a PhD, I'm telling you, if you go and write to any journal and you're like, I like to volunteer to do peer review work, which is judging the work of others, they will gladly send you work.
Yeah.
But I like that. Some of the other stuff we used in the past, unfortunately, Danielle, is not working as well as it used to be.
Mm.
Like skipping the green card and doing national interest waivers, which is a mechanism under EB2 classification. The amount of pushback from the government is
Wow.
so heavy right now. Like
Wow.
almost all those cases are getting requests for evidence, and it wasn't that way a year
No,
ago. Where the Biden administration pretty much said, if you're working in an emerging technology field, we are going to give you a national interest
that's
waiver.
right. Yeah.
And that's what we're talking about. Like that is a huge strike zone shrinkage in terms of how things are being adjudicated. The one that I think more companies should be thinking about, though, is this concept of global training for multinational organizations. If you have entities outside the United States, the L visa is really spectacular. There's no quotas. It has a spousal work authorization component to it for intercompany managers. There's an expedited means of getting permanent residency. Um, and I think it has a fundamental benefit to global organizations in ensuring more continuity with the way certain things are processed, handled from country to country.
Mhm.
I think it is like often overlooked as a solution. But let's just say, for example, you happen to be a foreign national from somewhere in Europe, and you
Mm.
come over to the United States, you study, you do your OPT, you're not selected in the lottery, but you work for a multinational company. You've already worked in the United States for a few years. Let's say they send you back to, I'm going to make you Italian. They
Yeah.
send you back to Italy to go work at the facility in Milan. You're there for a year. Maybe you're in a management program, maybe you're an individual contributor, but you've had that American experience at the mothership that you now are able to like transmit through to that Italian entity.
Yeah.
And then you can come back a year later, and all of a sudden you have a whole new lease on visa life within the United States.
Mhm.
So I do think this concept of globalizing training is something that does require a little bit more attention to for companies that can do it. Look,
Yep.
again, no cure-all. Not everybody's a multinational company. I'm not saying that you go and establish an entity for the purposes of visas.
Mhm.
But if you have that existing framework, it's something that should be considered.
Yeah. Amazing. Well, I want to turn it over to some folks for questions. We have 5 minutes, so we have enough time for a few questions. You can raise your hand, or you can pop in, but let us know, or you can write in the chat if there's anything that comes to mind. We have one question on what are the challenges and trends with cap exempt H-1B at consular processing level, which I can speak to from my perspective, but Jonathan, you obviously are filing cap exempt H-1Bs at your firm all the time, so you probably have a perspective if you want to start with. Have you seen any trends there?
It's kind of interesting. I think we saw more pushback before, surprisingly, where like some consular officers were actually questioning the validity of cap exemption. I haven't seen too many of those lately, to be honest with you. Now, where we're seeing problems is more on the vetting and the administrative processing side for all visa processing, Danielle. It's not just limited to cap exemption, but this extreme vetting that the administration put into place
Yeah.
is truly a challenge.
Yep.
It is slowing things down. The other thing, and I know nobody wants to hear this, but they're moving to mandatory interviews as of September 2nd. No more mail-in.
Mm.
So everybody's going to have to be interviewed.
Yep.
So you take that with the fact that Marco Rubio just cut 6,000 State Department jobs. You couple in the fact that a lot of people have already left, and visa appointment wait times are going to go through the roof.
Right.
It is going to get bad.
Right. Wow.
So, if you're thinking like, hey, I'm going to go home for the holidays and process my visa, like I would be booking that appointment now.
Right.
In fact, I can tell you places like Sydney in Australia and London are already booking out in
Yeah.
December. There's very few appointments available.
Yeah.
So,
Another reason for companies to start thinking about taking action prior to expiration of visas, given that there's increased RFEs and folks are gonna, run into issues if they are in their grace period and, or if they have to do consular processing and have to leave the country, it's gonna be increasingly challenging to get foreign nationals back in with those wait times. Raj, from our perspective, I actually am completely aligned with Jonathan's sentiment. Last year, we had more folks sent into administrative processing. We solved that issue. There was, with part-time, full-time employment, actually, no one ever questioned the cap exempt status or put anyone into administrative processing because of the cap exempt status. But certainly there's other factors when it comes to an individual that the consulates are looking at. So last year we had an issue with folks looking at a couple of our individuals who were only coming in on the 5-hour per week visa. Now we have everyone entering in with their full-time status as well. So we've solved for that challenge from our lens. We are seeing an increase in biometrics requests for our H-1Bs that we're filing. So that's an interesting change and a requirement for RFEs, not to your question, but just related point. Kind of interesting there.
yeah.
We had a question from Rex on what is the typical processing time to change status for cap exempt H-1B within the US. So Jonathan, if you want to talk about change of status from your perspective.
Well, it's pretty quick if you use the expedited processing. Typically, we tell people it's a 4 to 6 week lead time, in terms of preparing LCAs and filing and then getting the USCIS to change the status. If you're really on your horse and the government's moving quickly, you can get it done minimum of 3 weeks, but typically it's a 4 to 6 week exercise.
Depends on the attorney you're working with. If you're working with Jonathan, he's fast, so you'll be in the 4 to 6 week range. But some attorneys are.
Yeah, I got a good. I am very fortunate to have a great staff helping me out. But yeah, we try to move them quickly. Some attorneys will take longer on the prep side.
Yeah.
But it's in the grand scheme of things, it's fast.
Yeah, we're on about 4 to 6 weeks for our program, but we're also developing like massive amounts of documentation on the projects that our foreign national fellows are doing in that cap exempt status with the universities. So that's really what's going into our petitions for the fellowship program. For H-4 visas, what's your perspective? There was a lot of talk in the Obama administration about, the H-4 EADs, and then were those going away during Trump, the Trump admin won. What's the deal now?
It's funny, there hasn't been a heap of chatter about the
Right.
H-4 EAD this time around. I think it's probably on their list. Um, they seem to be more fighting these ideological battles when it comes to policy, less so on the mechanical ones. And I don't
Mhm.
think the general public quite understands the H4 EAD conundrum. It's a very, frankly, like I know for Indian nationals it's a huge thing, but in the grand scheme of things, it's not a massive amount of people applying for it, like something as ubiquitous as H1B. So right now, I think H4 EAD is on terra firma. I haven't heard much in the way of projected attacks on it. Um, but I would keep a close eye on it. I would definitely keep a close eye on it.
Cool. Well, we're at 4 o'clock, and I feel like our game of that was very effective, and we'll make sure that we actually will publish a summary of perception or reality of some of these
Well, I,
categories.
if I could just say one last final
Please
thing,
do,
and
please
I
do.
mean this in all sincerity, it's hard when you see a system breaking.
Yeah.
It's hard when you see something that you rely on starting to fall apart, and it's that uncertainty that creates the fear. But I think one thing we have to remember is that it also creates opportunity. And sometimes when something gets so broken, it does force Congress to act because they do represent the will of the people.
Mhm.
And whilst I think it has little to no chance of being passed, the Dignity Act was once again reintroduced to the House as a bipartisan bill.
Right.
And that has aspects for helping DACA, but for the first time ever, recalculates the way immigrant visa numbers are allotted so that there would be no backlog if it goes through.
Yeah.
And there's certain advantages for people being cap exempt if based on their degree.
Yes.
So I know things feel dark now,
Hmm.
but it doesn't mean that there isn't opportunity for light. And these kinds of panels and these kinds of presentations and people attending and making a stink and saying what they believe is how change and meaningful change will actually occur. So
Yeah.
I really appreciate you having me here today. It was
I love
cool.
that. I love that. We'll have to, I honestly, I need to capture that last piece and share it widely, because I think that that's the sentiment that a lot of, there's a lot of negative happening, and that sentiment, Jonathan, and the positivity and the folks that are really trying to get good information and find the solutions is a piece that's missing, and folks need more of in the space. So thank you for ending on that note and for all of this incredible information and insight. We'll be sure to be sharing it more broadly and getting short snippets out. So have a great rest of your day, everyone, and we will be in touch.
Bye now.
Thanks. Take care.